I'll now hand you over to Martin Vincent from Weightmans. I'm sure many of you are already familiar with Martin, who heads Weightmans' education team, is client partner for key university clients, and in a previous life worked in the senior legal position at the University of Manchester. Martin will be talking today about the UK Government Procurement Bill and the future of procurement. So thank you, and over to you, Martin.
Thank you. Just to make sure, can you hear me in the first question?
Yes.
Lovely. On that basis, welcome everybody to this session. This session will touch on the procurement bill, but it won't go into it in any great detail. My email address you can see there is available for two reasons. One is Weightmans are going to do 3 in-depth procurement bill / act webinars when it's been through the House of Lords, so we can talk about the actual detail rather than the probable detail. And the other reason is this talk was originally going to be delivered by our Brexit guru, a lady by the name of Jackie Bickerton. Unfortunately, she's having to have an operation on her foot today, so I am standing in. As it dwells on or deals with wider issues than just the procurement bill and talks about Brexit in general, questions would be appreciated to be emailed to me, and I can get an answer from Jackie when she is back on light duties, which shouldn't be that long. So if you want to sign up for the 3 procurement bill detailed drill downs, just send me an email, martin.vincent@weightmans.com. If you've got any questions, also martin.vincent@weightmans.com, and I will add you to either the invite list or I'll get an answer to the questions that you pose. As I said, I will touch briefly on the procurement bill, but we're going to talk about the principles really rather than the detail. One point to note for us lot in HE is the definition of contracting authority is very unlikely to change to any material extent. So if you were thinking you were or weren't a contracting authority before, there's really going to be nothing new in the new procurement rules that would alter that opinion one way or the other. Can I have the next slide, please? So what I'm going to cover here in this session is an update into where we are in relation to Brexit, some comments about Northern Ireland, the history of the evolution of the procurement bill so far, the Queen's speech, future for procurement and some general principles. And as I say, then there will be, if you have any questions, please email them to me and I will get Jackie to answer those. Just the next slide, if you will. So, referendum. On the 23rd of June, that will be the 6-year anniversary of the referendum vote, and a lot's happened since then. Not going to go into the politics of it. It's clearly a very divisive topic still. And we arrive at this point where we are celebrating the 6-year anniversary of that particular vote. The UK departed the EU on the 30th of January 2020. After much debate about the UK government and the EU, both sides reached some form of agreement, which is recorded in the Trade and Cooperation Agreement. The UK is obviously now outside of the EU and no longer subject to its rules, although some still followed by the UK. In the context of procurement litigation, all of the EU case law up until the 31st of January 2020 is still binding on the UK courts. It's what's called retained EU law. And as a result, most of the case law across the EU pre that date will be applicable to matters in the UK. The courts have also said that EU litigation since then and precedents set within that will be persuasive in how they will interpret and apply the rules in this country too. Obviously, we've got new border immigration arrangements, which have, it's fair to say, disrupted trade and the supply of labour in particular. Legislative change. So 2 pieces of domestic legislation underpinned the UK's legislative framework following the withdrawal from the EU. The first was the European Union Withdrawal Act 2018, and the second was the European Union Withdrawal Agreement Act of 2020. This amended the earlier act to give effect to the UK-EU Withdrawal Agreement. These 2 pieces of law did a few things. 1, they repealed the European Communities Act of 1972. 2, provided a transition period up to the 31st of December 2020, during which EU law, including the procurement regulations, would remain in effect. They converted EU law into UK law at the end of the transition period and preserved EU-derived domestic legislation, such as the procurement regulations, which would otherwise have lapsed. And this created another limb of retained EU law, as well as the cases I mentioned a little while ago. So this trade and cooperation agreement, it provides the UK can maintain a separate and independent procurement regime. The current procurement rules obviously originate from EU directives. The PCR 15 gave domestic law standing to the EU directive and came into force on the 26th of Feb 2015. Obviously, to note, that was done by what's called a statutory instrument. A statutory instrument is not as higher up the legislative hierarchy as an Act of Parliament. The Procurement Bill will become an Act of Parliament, which is the highest level of interpretation that we have within legislation. The purpose of the EU directives was to provide for, obviously, your main themes: non-discrimination during procurement procedures, the rules regarding the awarding of contracts, and how you draft specifications. And these are still the rules for now. The only change to date to the UK domestic legislation has been very minor, to include things like replacing references to the European Commission with references to UK ministers, changing the requirement to advertise so it refers to the UK's e-notification rather than the OJU. So current position of import and export of goods. 3 bits to this: tariffs, quotas and additional paperwork. Tariffs, the trade deal said there'd be 0 tariffs to apply to goods, but there are certain exceptions. However, the important thing to remember is there's this thing we call the rules of origin. So the rules of origin will protect goods from a tariff, and the rules of origin are more than 40% of its pre-finished value is neither of British or EU origin. So, example, parts from Japan coming through the EU will potentially attract tariffs because they're not made in the EU, and vice versa between Britain and the EU. Second part, quotas. There are no quotas on the number of goods that may be exported to the EU, provided that the goods again meet the rules of origin. Additional paperwork. I'm sure we've all enjoyed the additional paperwork involved in buying. I made the mistake of buying some parts for a bicycle from France a few months ago. After the 3rd or 4th page of forms to fill in, it didn't seem like such a good idea to do that anymore. But there are additional customs declarations. Driving within the EU is now different. You might need to get, depending on which bit of the EU it is, you need some different parts for renting a car. Fantastic. And a health certificate is required on all consignments of food being exported to the EU from the UK. Last one is conformity measures. In relation to conformity measures, if goods are placed on the UK and the EU markets, then there are 2 sets of conformity measures that will need to be adhered to. the UK and the EU, there is no establishment of mutual satisfaction. So what neither side has said that if it carries one, it'll be good enough for the other one. So that's a double the increased cost for business in doing that, in acting in that way. Next slide, please. Okay, so Northern Ireland. I'm sure we've all seen in the news what's been going on there, but to recap, although part of the UK, Northern Ireland continues to follow some of the EU rules post the Brexit divorce deal to keep an open land border with the Irish Republic, which is of course an EU member. That's called the Northern Ireland Protocol, and it's an agreement between the UK and the EU, which has been increasingly under threat because what it tries to do is reconcile the UK's freedom to diverge from the EU rules with the political imperative of keeping the land border with the Irish Republic open. And it creates a regulatory border between Britain and Northern Ireland, which remains aligned to EU single market rules and follows the EU customs code. Now, as of January 21, and at the end of the transition period, Northern Ireland left the EU's customs union with the rest of the UK, because the rest of the UK wants to pursue an independent trade policy. But in practice, it still follows lots of EU customs rules and is subject to EU oversight. The protocol ensures there are no checks on goods that move between Northern Ireland and Ireland, and indeed the rest of the EU. It does this by applying the EU's single market rules for goods to Northern Ireland and the EU's customs rules, which means that goods coming into Northern Ireland from the rest of, well, from Great Britain must be checked and or have paperwork to show they comply with the EU regulations, even if those goods never leave Northern Ireland. So the issues, it's widely commented, and you'll see it in the news, that the agreement isn't working and is not fit for purpose, and the layers of extra red tape, because Northern Ireland business has to simultaneously follow UK and EU rules in many respects, means that there's been disruption and shortages after the 1st of January 21, causing anger amongst some elements of the community in Northern Ireland, and there's been some civil unrest as a result. It's mainly unionist parties, and they support Northern Ireland obviously being part of the UK, and they argue that placing an effective border across the Irish Sea undermines Northern Ireland's part and place in the UK. The DUP, the Democratic Unionist Party, is refusing to take part in Northern Ireland's power sharing government unless its concerns are resolved, even though the DUP came second in May's elections to Sinn Féin. A new Northern Ireland government cannot be formed without its consent. So they're in a bit of a stalemate situation at the moment. And the current situation is the UK says the protocol has caused problems which were unforeseen by the UK government. It has led to unnecessary bureaucracy for businesses trying to move goods between Great Britain and Northern Ireland. But the EU say renegotiation of the Northern Ireland Protocol will not take place. Any unilateral action by the UK would face EU consequences and international litigation, possibly concerning the World Trade Organization as well. The EU set out their own proposals in October 21, and their idea was an 80% reduction on checks on food arriving in Northern Ireland, trying to halve the amount of paperwork. They proposed passing legislation to allow the trade on medicines between GB and Northern Ireland to continue unmodified, and also that they would relax rules so chilled meats could still be sent across the Irish Sea, whereas at the moment that they can't. Now, on the 17th of May, Foreign Secretary, who is Liz Truss, announced that the government will, and the phrase was, in the coming weeks, that doesn't really narrow it down, introduce legislation to change the Northern Ireland Protocol on a unilateral basis. This is means that the EU won't have any say in the change to the protocol. which, as I say, invites enforcement measures. Even up to United Nations could have jurisdiction there, but that would take years to get that resolved. Again, Liz Truss said the government's preference remains to reach a negotiated outcome with the EU, but the EU's current proposals do not address the government's fundamental concerns over the protocol. The Foreign Secretary also said legislation will make 4 changes to the protocol. Firstly, it will remove checks and paperwork on so-called green lane goods. These are goods moving from Great Britain to Northern Ireland that are destined to stay in Northern Ireland and are at risk of moving into Ireland or the EU. That is going to be quite difficult to define. If you think of all of the breaking bulk that happens in major shipments, how will it be guaranteed that no reseller or intermediary in the supply chain doesn't sell across the border in the Republic? It'll create a new dual regulatory system where Northern Ireland companies can choose to apply EU or UK's regulatory regime for goods, removing regulatory checks. To be honest with you, that doesn't sound like a very sensible idea, because you're going to just get a piecemeal adoption of different standards according to different choices made by business who may have competing agendas compared to the harmonisation of standards, etc. They want to ensure a single tax and spending regime across the UK. This will allow changes to VAT in GB to be applied in Northern Ireland, because at present the EU's VAT rules apply in Northern Ireland. They want to change the governance of the protocol to the same system as that for the EU-UK Trade and Cooperation Agreement, removing the jurisdiction of the Court of Justice of the EU, which currently has a role in enforcing European rules and settling disputes over the protocol. Because the UK is a sovereign nation, it can do that, but it's a bit like saying at what cost? Sanctions and extra tariffs and all sorts of barriers to increase to trade, etc., can be imposed by all sorts of different entities across the world. The EU responded, saying the announcement raises significant concerns, and that should the UK decide to move ahead with a bill disapplying, this is the phrase they used, with a bill disapplying significant elements of the protocol, then they will need to respond with all measures at its disposal. The EU said it's ready to continue discussions with the UK to identify joint solutions within the framework of the protocol, but added that the potential for flexibilities that haven't already been offered, our UK government has completely ignored those flexibilities and wants to not impose its own rather than explore the ones that have been offered by the EU. Can I have the next slide, please? Okay, so this is a bit of background to do with the procurement bill, really. So prior to Brexit, as you know, public procurement law in the UK arose from EU directives. Which EU directive, depending on which bit of domestic legislation you're referring to, in which they applied an overriding layer of the general principle, the treaty, the functioning of the EU, and unsurprisingly, the 4 core principles were proportionality, non-discrimination, transparency, and equal treatment. Now, when I get on to talk about the consultation, I want you to just remember the words I've used there, all enshrined in Regulation 18. Proportionality, non-discrimination, transparency, and equal treatment. So this is what the government says it's trying to do. So those are the rules. So what do they do to the laws? Currently, we've got the regulations. As I said, they are the public contract regulations, the concession contract regulations, utilities contract regulations, and there are some variants in Scotland that I won't list. Government's consultation started on the 15th of December 2020. You could say that was a bit late, because no one knew that was a hard deadline, did they? Of course they did. So the government published the Green Paper on the 15th of December. It was called Transforming Public Procurement, and it went out to consultation, and it wanted to, and I quote, significantly overhaul the UK's public procurement regime. The consultation deadline was the 10th of March 2021, and government intended to overhaul procurement regime, and in particular its rhetoric was it plans to cut red tape, reduce bureaucracy, help to provide wider social benefits from public money spent on procurement. It would introduce new rules for lower value contracts to allow more UK-based SMEs to win government business. It wanted to provide extra measures on transparency, meaning taxpayers were better informed about how their money is spent. It would introduce the ability to exclude poorly performing companies from winning valuable contracts and preventing spurious legal challenges. It would give awarding authorities the encouragement to consider how public contracts can support social or environmental issues and promote local communities, etc. Now, those of us who were around actively in this area in the 2014-2015 period heard exactly the same sorts of plans issued by the EU, which of course then included ourselves, about what the aim of the 2015 regulations was. So how far actually the new Act, as it will be, will move that on, really does remain to be seen, but it seems to be trying to get to the same place, just potentially by a different route. Now, government response to the consultation was published on the 6th of December 2021, and that outlined the proposals for implementation of the legislation. Some of those proposals reflect the original Green Paper ones, but others have been refined or abandoned as a result of the consultation responses. Also included a summary of the feedback received to the consultation, and although it was a summary, I don't know if you've read it, it's massive, but it's not an easy read, but some of it is relatively interesting. So what's going to happen? A couple of things are likely to change. The first, it wants to create a procurement review unit, a bit like Crown Commercial Services or Mystery Shopper or whatever that entity was. But this one is supposed to have teeth, as in it's not, if you're found to have not implemented the rules or applied the rules properly, there might be some measures. Now, how they're going to do that in higher education, I've got absolutely no idea. I strongly suspect that will happen when we're talking about central government bodies, so what's currently listed in Schedule 1, so not sub-central procurement bodies, which, if universities are subject to the rules, is the category they're going to go in, because there is no mechanism by which the Treasury can levy some sort of punishment directly on a university since the abolition of a block grant. So maybe they'll be able to do it in other indirect ways, but a direct enforcement is, unless governance of HE changes generally, is going to be really difficult for them to do. I can see it working in the NHS and the various ministries, but when we start getting down even to local government levels, it's going to be quite difficult. And we're furthest away from them being able to impose anything on a contracting authority, if indeed it is a contracting authority, is higher education, because it is the most independent, financially speaking. It wants to introduce a simpler regulatory framework. You might have seen mention of things like the more flexibility in terms of procedure. So a lot more like a light touch procurement being more generally available. Light touch obviously still has to apply the principles of equality, transparency, non-discrimination, proportionality. But how you actually get there means that you've got more flexibility in terms of how you design a procurement process. There's not the same split between selection and award stages, so that might be something that happens. Might feel a bit more like a light touch regime for most things, and that's what they mean by when they use the phrase using the right procurement procedures. You'll also have the ability in the new Act to enter into what they're currently calling a flexible framework. So, as you know, framework agreement at the minute is set in stone. There's no ability to enter a framework agreement once it's set. So you have your framework suppliers, and that's it. Now, they tried to do something about that with a dynamic purchasing system, but a DPS allows anybody at any time who can fulfill the SQ, not even any award questions, the ability to enter the DPS, which means that in practice, pretty soon after it's created, the number of suppliers on a DPS is massive, and there are no award stage questions already dealt with, so you have to start from scratch. So they're quite admin heavy, both to use because you have to invent your own award stage, and to administer because at any moment someone can just bang in an SQ and you've got to let them on. So this is an attempt to rectify those particular concerns. Another stated aim of the government is what it says it calls awarding the right contract to the right supplier. Personally, I thought that was what procurement was about all along. So it's going to be interesting to see what they think they're going to be able to bring to the table to help us all improve how we've been doing that. It also wants to create a framework that allows authorities to use the best commercial purchasing tools. I'd be interested to see the detail of that, but I think that's an area that's quite well boxed off as it is. In terms of the current regulations' ability to talk about whole life costing, take into account costs of depreciation, costs of disposal, all sorts of things that create a commercial model that is it functions well. Another aim is to ensure open and transparent contracting. Well, that's been pretty much the aim of all litigation in the UK relating to procurement for the last 15 years. So I'd be surprised if they can do anything more about that. And what they want to do is create effective contract management. So that I hope means that there's going to be more support for organisations who are seeking to do that. Can I have the next slide, please? So Queen's speech. My preceding words were the government's response to the consultation. They made it into this Queen's speech. Surprise, surprise. However, but following Brexit, the UK government made it clear that they wanted a wholesale change to the current procurement regime, want to see a system that enshrines in law the principles of public good, value for money, transparency, integrity, fair treatment, non-discrimination, and legislation to require contracting authorities to have regard to a new procurement policy statement. That's what they said. Where I think another significant change will be is this legislating to require contracting authorities to have regard to a new national procurement policy series of statements, a bit like PPNs, but with more teeth. Now, I said earlier that the government will struggle in terms of HE governance, to enforce breaches or consequences for breaches of what their policy notes say they're going to have to do. So what this does is it says that what they're planning to do is to say that thou shalt implement all of the PPNs. Now, previously, they tried that in the 2015 regulation, but they limited it to central procurement bodies. Now, whether this bit survives the Lords or not is going to make a big difference to all of our lives, because if it stays like it is, then all contracting authorities will have to put into effect the contents of the future procurement PPNs. I said before, directly, the government will struggle to do that in higher education, but by putting in the regulations that you have to implement it, that means that if you don't implement it, it's actually the economic operators who can say that you've breached the procurement regulations in that you haven't implemented the PPN. So what that means is that in terms of the PPNs, they don't need to have a direct enforcement mechanism on HE. They're going to leave that up to the marketplace, because they're going to create this mechanism by which the marketplace can enforce this correlation between the PPNs and the procurement practices of contracting authorities, which of course puts a great deal of onus on all of us, and me advising and you doing, to keep very much appraised of what comes out in the PPNs, because there could be the requirement of all sorts of redrafting of specifications, of pricing models, of award criteria, selection criteria, all sorts of stuff. As I said, whether that's going to survive the House of Lords, I don't know, but it's in there now. So one to watch, because that could be a big impact on day-to-day life, having to make sure tender packs and ITTs are constantly updated, that type of thing. And like I briefly mentioned earlier, the other big thing, so that's a big thing. The other big thing is this new unit to oversee procurement. It will have powers to review and intervene to improve contracting authorities' compliance with the procurement regulations. More big news if you're a ministry than if you're a university, but still could be a slight tweak to some sort of, they could give that role to the OFS. I don't know if they want to have it, or it would require secondary legislation to be passed, which is obviously going to make it a more long-term thing. So the procurement bill was published on the 11th of May 2022. It has made it to the House of Lords in what I have to tell you is record-breaking time, because I think the Conservative Party had other in-house issues to deal with rather than a lengthy debate on this particular topic. But it has been held up at the Lords. What it's going to do when it becomes an act, it will revoke public contract regulations, concession contract regulations, utilities contract regulations. Now, we will be given a lead-in time for that. It's not like the next day that's going to happen. Last time, some bits of the 2006 regulations rolled over for over 12 months into 2017 before they were lapsed. So what I predict is when it is passed as an act, we'll have about a year to get our changes made, reviewed, understand what all this means, and be able to make a good start. But you never know. It could be a really short time, because obviously it's a political aim to trumpet that you've reduced red tape, when actually you've not. You've just changed it a bit. So they might want to do it a bit earlier than that. But the last few times it's been done, we've had approximately a year to do it. And this is the government's stance on what it will achieve. The introduction of new exclusion rules to tackle unacceptable behaviour and poor performance. I thought we had that already. Provision to allow buyers to take into account a bidder's past performance. Yeah, we got that already. Requirements for buyers to have regard to government strategic priorities for procurement set out in the National Procurement Policy Statement. Yeah, that's new. Yeah. The placing of the objectives of public procurement on a statutory basis, and these will be to deliver value for money, maximising public benefit, treating suppliers equally and without discrimination, and acting with integrity. The government says that the potential benefits are that they will, through compliance with the National Procurement Policy Statements, take control over the use of public money, i.e. want a much bigger say in how contracting authorities spend their money. which is kind of philosophically okay if central government is giving you that money to spend and you're a ministry. It's kind of not okay if you're operating in my philosophical position, if you're operating in a quasi-open market like higher education is, where how you actually spend money that hasn't been derived from the government is in fact the result of funding from in relation to student loans, for example. They're going to try and control that, which I think philosophically is more difficult to get your head around than a direct block grant allocation. They say they want to reduce red tape. Well, they always say that. Driving innovation is another one. Making doing business with the public sector simpler. That could do with some work. Imposing tougher actions on underperforming suppliers and creating a transparent system. All of the benefits there were kind of the aims of the 2015 regulations. So the devil will absolutely be in the detail on that one. So where are we up to right now? 11th of May, bill introduced to the House of Lords to receive its first reading. 25th of May, bill received its second reading in the House of Lords, and it's currently waiting a debate during the committee stage, which usually starts 2 weeks after the second debate reading, and lasts up to 8 days, but could go on for longer. And the committee stage involves a detailed line-by-line examination of the separate parts, which are, in this case, clauses and schedules of the bill. And they start at the front of the bill and do a page turner all the way through, and any member of the House of Lords can take part. So that's where we are currently. And the final slide, if you will. So thank you for listening. And as I said at the beginning, I am not Jackie Bickerton, our Brexit expert. So I've done the best that I can. I got on safer ground as I went on. Questions, please, via email, so I can get a proper answer out of our knowledge management team. And as I say, if you want to sign up to the 3 webinars that will deal with the Procurement Act in great detail, again, ping me an email. Seeing one from you, Mr. Fendel, thank you very much for that. So I'll add you to the list. Anybody else wants to get signed up, just ping me an email and I will send you an invite. But apart from that, thank you very much.
Wonderful. Thank you, Martin. So as Martin said, if you email over to Martin any questions, if you don't have Martin's contact details, alternatively, you can send them to us and we'll make sure that they get to the right person. So that concludes our session. Thank you for your time today, Martin. The next session is starting at 12 and is focused on mindful living, which is probably a good bookend to a presentation on Brexit. So the session can be accessed via the link in your calendar, or the link is also available in the chat function. Thanks, everybody, and goodbye.